Morning, I'm Eric Blank, and this is the Commissioners' Weekly Meeting for October 18th, 2023. Commissioner Plan, are you ready to approve the consent agenda as presented, or any preliminary comments?
I'm ready to approve the consent agenda. Thank you.
Commissioner Gilman?
I too am ready to approve the consent agenda.
As am I. Proceeding number 23AL-0243E, Public Service Company Phase 2 rate case. Mr. Acera, Ms. Harper.
Yeah, good morning, Commissioners. I'm here this morning to recommend that you adopt our standard hearing procedures for this case, which is Public Services Phase 2 electric rate case. With answer testimony due on Friday, I think the parties are going to want to know what the procedures are for filing electronic exhibits, and perhaps more importantly, which block of exhibit numbers they've been assigned. Also, for your decision today is whether or not the proceeding is going to be in person or hybrid. I think that you all had talked about that briefly at a previous CWM, but to my knowledge, no decision was made on that. The parties have jointly requested that the hearing be remote, and the hearing is currently set for December 11th through 15th and December 18th and 19th. So with that, you've got my recommendation on the procedural item, and I'll leave it to your discussion.
So I guess, Mr. Acera, I've understood that the company wanted in-person hearings. Are they part of a motion asking for the hearings to be remote? That's news to me.
So at least in this particular instance, and I don't know that I have in the consensus procedural schedule that was filed is where I believe the parties, and I believe Public Service filed that, is where they made the statement that the parties were requesting a remote hearing here. And I can pull that up and double check for them.
My sense is we were under some pressure to do it live. But let me check with my colleagues. Commissioner Gilman, I suspect you'd be happy to do this remotely, but are you able to do it live if it's possible and that's what people want?
Yeah, notwithstanding that obviously weather can be an issue in December moving around the state, but yeah, I mean, if the parties filed jointly something saying they'd all like it to be remote, I wouldn't see any reason to go against that. But I would be able, if there's some sort of request to have it be in person that we're not aware of, I'm amenable to that as well.
Commissioner Plant?
Yeah, I was planning on being in person, so I've got that. But if we wanted to do it remote, I could do that as well. I think one of the concerns when we discussed this last time was doing part of it in person and part of it remote might not be fair to parties that were testifying on the remote part versus the in-person part. And so I think we were trying to, have it be all either in person or all remote or all hybrid, but not mixed up. So
All right, well, why don't we leave this with you, Mr. Acera? I think you have all three commissioners available and willing to do it in person, but if the parties prefer to do it remote, we'll do it remote. We will keep all three of us together. We'll all be remote or we'll all be in person, and we'll do the whole hearing live. So I think that's where we're at. And if you just want to check with the parties and make sure their preference and confirm their preferences to do it remote, that'd be great.
So I can tell you that they filed an unopposed joint motion and they request a remote as evidentiary hearing. So the parties have made that request. They want it remote. There's nothing else that I've seen in the record that indicates otherwise. So if you want to hold off on that, and just double check for some reason, what I would suggest is that at the very least today, you make the decision to issue the standard sort of procedural decision, the hearing procedures. adopt those that we normally do, because the parties are going to need to know how to number their exhibits when they file them on Friday. But as it is, I think it's fairly clear the parties have requested that this be remote.
Let's fix the procedural schedule. Commissioner Plant, you okay with setting the procedural, the normal procedural issues?
Yeah,
Commissioner Gilman?
Yes.
As am I, and I've heard otherwise on the live versus remote. So can you just run that down, talk to the company, and if you can confirm it, we'll do a remote hearing. If that's just a form pleading, just tie that down for us, would you, Mr. Acera?
Yeah, we'll see what we can do. And if it has to come back for that piece, then we'll go ahead and do that. But for now, we'll get the procedural, our hearing procedures out. So thank you for that.
No, thank you. And sorry for the confusion. Proceeding number 23A-0392 EG, Ms. Dundas, Mr. Mendelson.
Hello, commissioners. I'm Lindsay Dundas of your commission council. I think the whole team's with me today, including Ms. Rosati, Ms. Harper, Mr. Mendelson, and Mr. Davis, if any questions arise during this discussion. This matter is Public Service's inaugural Clean Heat Plan, filed pursuant to Senate Bill 21-264, which I'll refer to repeatedly today as the Clean Heat Statute. I plan on presenting the two pending motions and the respective responses to both, and the commission has not yet set a procedural schedule for the remainder of this proceeding, so we can address that today, contingent on the rest of the discussion. So unless there's any preliminary matters the commission would like to discuss, I can summarize the motion for partial summary judgment.
I think I'd jump into it, and then we'll open it up for comments, questions, votes, wherever
Great.
my colleagues want to take it.
So on September 6th, Boulder, Crest, Coatzacoalcos, NRDC, Physicians for Social Responsibility, Sierra Club, SWEEP, UCA, and WRA jointly filed a motion for partial summary judgment. In sum, the joint movements request that the commission grant summary judgment to and rule that the commission lacks legal authority to approve certified natural gas, or CNG, as well as offsets in this proceeding. To support the request, they argue four main points. First, that there's no genuine issues of material fact present, and thus summary judgment is legally appropriate. Also, they argue that the commission cannot approve CNG and offsets as a matter of law because the Clean Heat Statute, quote, does not allow public service to rely on the indirect emission reductions from CNG and offsets to achieve the clean heat emission reduction targets. They state that the commission can only approve additional measures that reduce the categories of emissions enumerated in 40-3.21083C, and CNG and offsets do not meet that standard. They further argue that CNG and offsets cannot be considered recovered methane, so the commission cannot consider the, quote, indirect emission reductions associated with them. They assert that the company violated numerous statutory filing requirements because it calculated its reduction in emissions from activities other than the distribution and use of gas, and because it presents a preferred portfolio that they contend cannot legally be approved. Finally, they assert that the commission cannot approve CNG and offsets within this proceeding under its, quote, general authority, because this proceeding was filed solely to approve the company's clean heat plan. Based off these main arguments, they request that the commission grant summary judgment, rule that the commission lacks legal authority in this proceeding to approve CNG and offsets at all, and order the company to identify a legal preferred portfolio, either through supplemental draft or an amended application, or order the company to strike all testimony regarding CNG and offsets from the current application. In response, the commission has received responses from Public Service, jointly from the Colorado Decarbonization Coalition, the City of Pueblo, the County of Pueblo, Pipe Fitters, and Project Canary, which I'll refer to as the Pueblo respondents, Denver, and then from CEO and the division jointly. Summarizing the main points of each response, I'll begin with Denver, who generally supports the summary judgment motion. Denver argues that in addition to the undisputed facts laid out in the motion, it is also, quote, indisputable that neither CNG nor the offsets proposed by the company reduce carbon emissions from the distribution and end-use combustion of gas or meet an approved recovered methane protocol. Denver agrees with the movement's legal conclusions, but takes it a step further and also argues the only type of resources that contribute to compliance with clean heat targets are statutorily defined clean heat resources. Moving to the highlights of CEO and the division's response, they also generally support the summary judgment motion. CEO and the division agree that the two, quote, undisputed facts put forth are true, and also add a third undisputed fact that neither CNG nor offsets are listed in the statutory definition of clean heat resources or recovered methane, and neither CNG nor the offsets proposed in the company's preferred portfolio reduce carbon emissions from the combustion and use of gas. While CEO and the division do not dispute that the Clean Heat Plan can include additional measures, they argue that the statute only allows for clean heat resources to count towards the target. They reiterate concerns about double counting across industries and note that Colorado's greenhouse gas inventory is not designed to accommodate the type of cross-sector emission accounting that the company is advocating for. Finally, they argue that it's inappropriate for the company to modify the workbook within this proceeding because the Clean Heat statute contemplates the division would work in consultation with the commission to develop and revise that workbook. Moving to a response filed by the Pueblo respondents, they oppose the summary judgment motion in its entirety. Overall, they argue that it should be denied because it fails to clearly articulate precisely what facts are undisputed, so it fails to carry their burden under the legal standard for summary judgment. Excuse me. Moving to the company's response, the company also opposes the summary judgment motion, except that it does agree that it's appropriate to reach a legal conclusion early in this proceeding on the issue presented. Overall, Public Service argues that Senate Bill 21264 allows for the inclusion of CNG and offsets because the statute expressly allows for, quote, other measures to be included in a clean heat plan to, quote, reach the targets in a cost-effective manner, and because it explicitly contemplates the use of non-enumerated clean heat resources as evidenced by the portfolio requirements in Section 4C and the approval standard in Section 6D, both which require clean heat resources to be used to the maximum extent practicable. Public Service also takes issue with the joint movement's delineation between direct and indirect emissions and states that it's both incorrect and not found in statute. While the company agrees that Section 3A of the Clean Heat Statute requires emission reductions from gas distribution utilities, it argues that CNG and offsets do in fact reduce emissions from gas distribution utilities by reducing the intensity of emissions associated with gas purchased and delivered by the utility. Public Service argues that the Commission may approve the use of CNG and offsets under its general authority to regulate utilities within this proceeding. It concludes its response to the policy discussion that argues that full consideration of the company's proposal is in the public interest and that granting the motion would cut off important discussion and lead to greater greenhouse gas emissions in the near and medium term. Public Service states that the motion could also harm consumers because the portfolio using only clean heat resources is substantially more expensive and would slow the company down towards meeting the 2030 target. Finally, it argues that granting the motion would lead to delays in the proceeding and would improperly cut off debate and affect the rights of interveners who do not join the motion. So that's the motion for summary judgment and the responses. I can pause here if the Commission thinks general discussion of the filing would be helpful. Otherwise, I'll move to the motion for leave to reply.
Commissioner Gilman, Commissioner Plant, any general comments or should we move on? Commissioner Plant, you okay if we keep going?
Yeah, that sounds good to me.
Commissioner Gilman, would you? Okay, keep going, Ms. Dundas.
Thank you, Chair. Excuse me. The movements filed a motion for leave to reply pursuant to Commission Rule 1400E. They argue that they're entitled to an opportunity to respond because the company misrepresents facts regarding their legal arguments related to both the movement's discussion of the inclusion of non-clean heat resources and by representing that the movements try to show that CNG and offsets are types of recovered methane when the movements say they actually make the opposite claim. The movements also argue that the Pueblo response contains an incorrect statement or error of law because Pueblo misrepresents the movement's partial summary judgment motion as a request for full summary judgment. So their recitation of outstanding policy and factual determinations is irrelevant, according to the movements. Both Pueblo and the company filed responses in opposition to the motion for leave to reply. Both essentially argue that the motion does not meet the standard in Rule 1400. So with that, I'll pause for a vote as to whether to grant the movement's motion for leave to reply and to whether to consider the movement's proposed reply, and I can provide a recommendation if you want.
You want to do your recommendation and then we'll come back with a vote, comments, discussion.
Sure. The Commission may grant leave to file a reply pursuant to Rule 1400 if the movements demonstrate a material misrepresentation of fact or an incorrect statement or error of law. We recommend denying the motion for leave to respond because leave for response should be granted in rare instances where there is actually a material misrepresentation or error of law present. Here, the fact that the company and Pueblo present conflicting analysis or misunderstand the movement's argument does not comply with that standard. The commission has the information and arguments that it needs to rule on the motion for summary judgment without the need for this response.
Commissioner Plant,
I support that recommendation.
Commissioner Gilman,
I agree.
as do I.
Thank you, commissioners. Because you just voted to deny leave to respond, I will not summarize the movement's proposed response. So we're now ready to address the merits of the summary judgment motion, and I'll start with reciting the legal standard. Pursuant to Commission Rule 1401F, a motion for summary judgment may be filed in accordance with Rule 56 of the Colorado Rules of Civil Procedure. Summary judgment is proper when the moving party can demonstrate that first, there is no genuine issue as to any material fact, and second, that the moving party is entitled to a judgment as a matter of law. I suggest we address the first prong of the legal standard first, which is whether the movements have shown that there's no genuine issue as to any material fact. The summary judgment motion argues that the only facts relevant are that this is a clean heat plan application and that the company requests within its preferred clean heat plan portfolio approval of CNG and offsets. The motion states that there is, quote, no factual dispute regarding the sectors of the economy from which CNG and offsets would allegedly reduce emissions. CNG refers to efforts intended to reduce methane emissions in the upstream oil and gas sector, and the company's direct testimony describes relying on offsets from sectors outside the gas sector like agriculture and forestry. CEO and the division in Denver both add that there's another undisputed material fact, stating that it's also indisputable that first, CNG nor offsets are listed in the statutory definition of clean heat resources for covered methane, and second, that neither CNG nor offsets proposed in the company's preferred portfolio reduce carbon emissions from the combustion of gas in customer end uses or meet an approved recovered methane protocol. The Pueblo respondents proffer a list of, I'd say, 6 or so pages of facts that they characterize as disputed, and Public Service argues that CNG and offsets, quote, do in fact reduce emissions from gas distribution utilities by reducing the intensity of emissions associated with gas purchased by the utility and delivered through its system, or by offsetting those emissions. So the first decision point is whether the movements have carried their burden to show that there's no genuine issue of material fact present, which is the first prong of the legal test for a motion for summary judgment. I'll pause for discussion and provide a recommendation.
Why don't you do your recommendation and then we'll open it for discussion, comments, a vote, wherever it goes.
Thanks, Chair. We recommend finding that there are genuine issues of material fact present, including whether CNG and offsets reduce emissions from gas distribution utilities. Taking the record in the light most favorable to the non-movement, which here is Public Service, we do not think that the joint movements have satisfied their burden to prove that there are no disputed material facts. While the joint movements and the company seem to agree that the Clean Heat Statute focuses the utilities and the commission on reducing emissions from the distribution and end-use combustion of gas, they seem to disagree whether CNG and offsets reduce the specific category of emission. Given this dispute, we think the commission would be better off developing a record as to whether those additional measures actually do reduce emissions in compliance with the Clean Heat Statute.
Commissioner Plant, anywhere you'd like to take it.
Yeah, so if I understand correctly, what we're discussing is whether or not we've met the burden of the legal standard that determines that there's no dispute of facts. Is that correct?
That's correct. And if you do determine that there is disputed facts at present, then the motion will have to be denied. However, that doesn't prevent you from having additional discussion once we've considered the motion.
Yeah. So if we were to do that, then, and we wanted, one of my concerns is resolving this before the other parties that need to submit their plans in January, I think, so that they have clear guidance to go by. And what you're suggesting is that if we deny the motion, we would have a hearing that would be able to happen prior to when the filing of those other entities would take place, so that we could give them some guidance.
So I think you're referring to the other 3 gas distribution utilities regulated by the commission need to make clean heat plan, or at least the ones that hit the customer count need to make clean heat plan filings in January. There's an opportunity to have a discussion about ways to provide guidance on those filings that we can have today, but I don't think that's necessarily something that goes to the question of whether the movements have determined have made a showing that there's no facts in dispute.
Gotcha. Okay. I think I know where I am on this, but I'd love to hear my colleagues' comments as well.
Commissioner Goman, anywhere you'd like to take us?
Thanks, Ms. Dundas. Yeah, I mean, I think as Ms. Dundas has described, there is dispute among the parties about some of these facts. And so for that, you know, the extraordinary step of granting the summary, I'm going to get the name wrong, the summary judgment might not be appropriate. But I would like us to go, you know, if we decline to approve the motion, I would like us to move on to the specific legal arguments individually that were made by the movement, because I agree with you, Commissioner Plant. I think it's important to resolve this matter up front, as we heard from every party, at least from the movements and the company, both think it's very important to discuss these legal issues and get some resolution early in the process. And so to me, that is somewhat of a separate issue, whereas we do see the parties disagreeing on some of the facts. I think that is apparent. So I would move on from the motion and begin to discuss the actual legal questions at issue, for which I have some comments, but I will reserve them until we get to that part. But for now, in terms of kind of the extraordinary legal threshold here, I would agree that at least the parties have some dispute about what these facts are.
Well, I also agree with the recommendation and Commissioner Goman's request to get onto the legal interpretation. For me, the statute sets up targets with at least 4 separate components: an emission reduction target, a deadline for achieving that reduction, guidance on cost limitations, and the resources that are favored to meet the reductions targets. Although subsequent evidence from the parties may ultimately refute this, based on the evidence in the record to date, it seems like it may not be possible to successfully reconcile these 4 competing goals. For example, to hit the emissions target in a timely way may require greater expenditures than the legislature would like to see. If we kept spending at or around the cost guidance provided by the legislature, timely emission reductions in the target amount may not occur. So given the challenges associated with hitting all 4 of these goals, and given where we're at in this case, I think it's premature to exclude CNG and offsets, as it's at least, you know, possible that these resources could help to better reconcile these competing statutory elements. So like council said, I believe there is a material dispute about whether or not CNG and offsets in fact reduce emissions from the distribution and end use combustion of natural gas. And so I do support council's recommendation. But like you, I have questions about the role of these resources, and look forward to having the conversation about the legal interpretation. So Commissioner Plant, I think we're on track to deny the motion for summary judgment, given the legal standard, but about to move on to a discussion about the legal standard for summary judgment, but about to move on to the statutory interpretation issue around the Clean Heat Plan. So any further comments, thoughts?
Nope, I agree.
Commissioner Gilman, anything else before we move on?
No, yeah, I think if Ms. Dundas can take us through some of, you know, how she sees the statute and the legal questions that have been raised by the movements, that would be an appropriate discussion. I'm not 100% sure you and I are on the same page, but we'll get there when we get there, I think.
Ms. Dundas, take us there.
You guys keep taking the suspense away from my script, but we'll move on. So you
I'm not going
determined,
to apologize.
Chair, we're on YouTube now. We have to keep the discussion
Yeah.
excited.
You keep the theater.
So it sounds like the commission has determined that the movements did not satisfy the first prong for the summary judgment legal standard, so therefore we need to deny that motion. However, as it's been alluded to, the company has requested that the commission resolve now, before the case proceeds further, the legal question as to whether the company may bring forward CNG and offsets as emission reduction measures in this proceeding. Based on that request, we can continue with that discussion outside the context of the motion for summary judgment if the commission wishes. It sounds like they do. So the differing statutory interpretations presented by the motion and responses can be summarized into a series of questions that I think can be answered by the clean heat statute. First, can the commission approve a clean heat plan that contains non-enumerated clean heat resources? And if so, can those non-enumerated other resources count towards utilities' progress towards the clean heat standard? Second, if the commission can consider non-enumerated resources, are those constrained to only those measures that reduce emissions from the distribution and end use of gas? And finally, is the company's filing sufficient or in violation of the clean heat statute? We think there's a harmonious way to interpret the clean heat statute that reflects the majority of the interpretation put forth by the company in the joint movements. I can provide that as a recommendation, or I'll pause here for further discussion by the commissioners.
Yeah, if you could provide that recommendation to give us some structure, that'd
Sure.
be great.
So beginning with the first question, I'd suggest that the commission clarifies that under the clean heat statute, the commission has the authority to approve or decide non-enumerated clean heat resources as part of a clean heat plan, and that those non-enumerated resources can count towards compliance with the clean heat statute targets. This is evidenced by several provisions in the clean heat statute, including section 40-3.2-1084C2, which lays out the filing requirements of a clean heat plan. Requires the utility to present several portfolios, including an A, one that uses, quote, clean heat resources to the maximum practical extent, and B, one that uses, quote, only clean heat resources. Further, in section 4D, the statute states that to demonstrate compliance, a utility must, quote, utilize clean heat resources to the maximum extent practicable and count greenhouse gas emission reductions resulting from its use of those resources. This filing requirement section can be read harmoniously with the commission approval section in section 6, which requires the commission, when evaluating a clean heat plan, to consider whether the plan, quote, achieves the clean heat targets through maximizing the use of clean heat resources. To read the statute consistently and harmoniously, one cannot ignore the language and the repeated use of maximum extent and maximizing the use of clean heat resources, necessarily suggesting that a plan can include something other than those clean heat resources. Turning to the second question, which is the commission's consideration of non-enumerated resources, turning to the second question, which is whether the commission's consideration of non-enumerated resources is at all constrained, we suggest clarifying for the parties that the commission can consider non-enumerated resources, but only if those measures reduce emissions from the distribution and end use of gas in compliance with section 3 of the clean heat statute. We agree with the joint movements that section 3 of the clean heat statute provides an important limitation on what emissions can count towards the clean heat target. Section 3 explicitly provides that the purpose of a clean heat plan is to demonstrate that a gas distribution utility will achieve a reduction of carbon dioxide and methane emissions from the distribution and end use combustion of gas. So in sum, my recommendation is to make the threshold interpretation now that Senate Bill 21-264 gives the commission the discretion to approve a clean heat plan that includes non-enumerated clean heat resources, as long as the commission finds that the clean heat plan maximizes the use of clean heat resources and the non-enumerated resources achieve a reduction of carbon dioxide and methane emissions from the distribution and end use combustion of gas. This leaves open the question of whether the company's application with its CNG and offset proposals is lawful under the clean heat statute. More specifically, whether the CNG and offsets proposed by the company can in fact achieve a reduction of emissions from the distribution and end use of gas. At least I recommend finding at this juncture that it's premature to make that determination and that the issue could benefit from the further development of the factual record. So I'll pause here for a vote or your continued discussion on whether the commission agrees with the statutory interpretation I just went through and would like to include it in the written decision in today's deliberations.
So again, Commissioner Plant, take the discussion anywhere you'd like to vote, comments, questions.
Yeah, I think that, there's there's two issues here. One is about the plan and what is about the commission can do, what the commission can do. And I think that within the statute, it seems clear that the commission can determine, various different components if we determine that they're within the in the public interest. So I don't know that there is a limitation in that way of us considering various things within our ultimate decision. I think that so I would agree with the recommendation on the interpretation in terms of our authority. I think that the second issue, which is what constitutes a clean heat plan and what are and whether or not it's a part of the distribution and combustion, is a much more complicated question. So I don't know. Are we deciding first on the authority question? So I would agree with the recommendation from council on the determination of PUC authority.
Commissioner Gilman, take this wherever you'd like to go.
Thanks. I'll try and hit each of your points, Ms. Dundas. As far as non-enumerated resources, I would agree with your recommendation that the language in the statute does appear to leave that leeway for the commission to include non-enumerated resources under the conditions that you stated. That first, clean heat resources as they're identified within the statute need to be maximized, and also that the emissions reductions need to occur in the distribution and induced combustion of gas. So, what you indicated there meets my general understanding with the leeway that I think we've been given in the statute. With regard to the last point, and kind of the next logical question, if those emissions reductions have to occur in the distribution and end use or distribution and combustion of gas, then where does that leave offsets and certified natural gas? And are we prepared to determine that today in terms of do those two, if we're all agreeing, which we'll wait and hear from the chair, but if we agree that the emissions reductions have to occur on the distribution and end use of the gas, do offsets and certified natural gas actually achieve that? And therefore, could they be part of a clean heat plan as is dictated by statute? I actually believe we have the record before us to decide that discrete question. The company has included extensive direct testimony from multiple witnesses as to the specifics and the arguments for applicability of these emissions reduction sources. And they also had the opportunity to put forth arguments in response to the motion before us, where they could specifically rebut the claims made by the movements where they were essentially trying to argue that these were not applicable areas for emissions reductions. So for me, I'm ready to decide this today. Yes, potentially we could prolong this and have some more process around getting more information on this. But given the testimony and arguments we already have before us, I just don't see a very high likelihood that anything would change or come to light. So first, as to the offsets proposed don't appear or even purport to reduce emissions in the distribution and use of natural gas as required. While I think it's admirable for the company to reduce emissions through other means and in other sectors, it doesn't appear to have any direct link to the specific boundaries in which emissions are required to be reduced and upon which the baseline for those reductions has been built by the legislature. Mr. Weinberg's testimony indicates as much when he describes carbon offsets as, quote, a reduction in emissions of carbon dioxide or other GHGs made to compensate for emissions elsewhere. The emissions reductions are, even by the company's own description, elsewhere, apart from the distribution system, apart from what was included in the baseline, and apart from the boundaries specifically dictated by the legislature as far as the boundaries of emissions considered in the Clean Heat Plan. Deviating outside of the boundaries set by the legislature into reductions from other sectors may fundamentally alter the math and the intention set by the legislature, especially when the baseline doesn't include these sectors. So we would be claiming credit for something being reduced that technically never existed in the baseline before. And the company doesn't really give in-depth relevance to why these offsets actually have anything to do with the distribution and use of gas. With regard to certified natural gas, the company's own witness, Ms. Quillian, I said it right, plainly describes the emissions reductions from CNG as, quote, upstream emissions in her direct testimony. She goes on to lay out the company's intent to voluntarily help move the market on reducing upstream emissions. While this interest on the company's part is admirable, it does little to sway my understanding of what should or should not be in bounds for inclusion in an approved clean heat plan. Dr. Lieb gets into greater detail about CNG with the company's extensive arguments in their direct case for its inclusion. She specifically indicates that CNG emissions reductions are outside of the LDC sector. And while it's nice to have emissions reductions everywhere, we simply don't have that task or latitude before us with this legislation, which to me clearly indicates that unless otherwise enumerated as a clean heat resource, the expectation is that the emissions reduction should come from the distribution and end use of the gas. The company relies upon the argument that CNG and offsets do reduce emissions from gas distribution utilities by reducing the intensity of the emissions associated with the gas purchased by the utility and delivered to its customers. This is difficult as the company's on record that those emissions reductions occur clearly upstream of the delineated system boundaries in which we're supposed to consider. And I believe this is more than a technicality. I think this is an intentional boundary condition set by the legislation. In response to the motion, the company also compares CNG emissions reductions to those in municipal solid waste or wastewater treatment facilities. However, they fail to recognize that the resources to which they're comparing are specifically enumerated by the legislation. And CNG or offsets were not, marking a dramatic distinction in that comparison. The inclusion of the others was a direct and deliberate choice in the legislation, and the same is clearly not true of something like certified natural gas. So for me, I've given extensive consideration to the company's arguments they've put forth already in direct testimony, as well as in their response to the motion where they understood the direct challenges to these resources. And you know, I'm not sure. I know we could go a route of ordering, you know, additional testimony and process and hearings. But to me, these are fairly concrete issues that I really just don't see a reasonable opportunity to overcome. So for me, I would be very comfortable right now making the decision that CNG and offsets, as they've been presented in this plan, do not appear to me to be something we can include to meet the standards for a clean heat plan.
Yeah, I'm not there yet. I would agree with council's interpretation of the statute, but I think it's a matter for hearing and a factual determination about whether they comply or not. I would not try and do some preliminary process. I just leave it to the normal process and go to hearing in the spring about whether they comply with the legal standard. So I don't see a basis for making a factual determination that it's impossible for these at this time. We may land there with a complete record in front of us in the spring, but it just seems premature to make the factual determination that these resources can't comply with the legal standard. And it may be a heavy burden. You know, I don't necessarily disagree with anything you've said in terms of characterizing it. I just think it's premature to make that determination at the current time. So I'll turn it back to you, Commissioner Plant, see if you have any thoughts on this. Then I'll turn it back to Commissioner Gilman and maybe council.
Yeah, I'm in agreement. I think that, you know, what Commissioner Gilman has laid out is it makes a lot of sense. I just don't know that we have a full factual basis for making that determination that would uphold it. I am also I'm also hesitant to wait until spring to make this decision, because I really think we need to clarify this sooner rather than later. Because we are going to have, not only, the company's submission, but we're also going to have the other companies in January. And I think that we need to give them some clear guidance. I think that the concerns that are raised, I think, express at least what our inclination is as commissioners for what we want to see in a plan. My question is whether or not the evidentiary record is complete enough to maintain that, and if not, if we can make a determination through a hearing process earlier than in the spring.
Commissioner Gilman.
Yeah, I think that's an interim step, Commissioner Plant. We could do something like some testimony and maybe a hearing, say in early December or something, on this discrete issue. That to me would certainly be preferable to leaving it in the full bucket. First of all, because we have a majority of the parties asking us to settle this sooner than later. It is a massive issue in a first of its kind filing with plenty of issues and plenty of parties, and this will suck all of the air out of the room. This is going to be a very significant distraction and time commitment for all of the parties, whereas we could focus on other issues, especially if there's an ability to make a more substantive finding on these particular issues and pull them out. And I think that that's necessarily what a lot of the parties are asking us to do, because they understand the amount of time and attention that's going to get devoted to a very narrow set of issues, but that have very significant, outcomes or repercussions in terms of that decision. So I'd put your suggestion as my second place finisher to maybe have some sort of interim hearing in like, December or something to settle this issue. I think that probably necessarily delays things by a month and a half or two, as far as where we are now, which might be doable. I think, honestly, part of my stance is the company's had at this point multiple opportunities to argue this. And I just don't think there's a reasonable expectation that new arguments will come to light on this. I would presume they did their best on the reply to the motion, which they knew was a significant threat to the inclusion. So, I think that's a possibility, is like to go to hearing. I think that's far preferable than going to hearing with all of the issues. So I don't know that you'd necessarily get my vote. If you need it to prevent it from being in the full hearing, sure. But
well, a couple of comments. First, I'm really worried about our schedule in December. We have the phase 2 of the ERP to decide. We have phase 2, 7 days of hearing, and phase 2 of the electric public service company rate case. Then we have 10 days of hearing in January on the TEP. So I think it's really problematic to add another 2 days of hearing into our schedule in December. And I don't really disagree with you that it's it's unlikely that the company can satisfy the evidentiary burden to meet this statutory interpretation. The problem is that's just not the standard that we have in, really what we have in front of us. It's sort of, feels to me that we're, making a premature determination on an incomplete factual record. So that's my caution. Even agreeing with everything you said, it still feels premature to roll that out. And And given the difficulties with reconciling the competing elements of the statute, it doesn't seem unreasonable to me to let this play out. So I don't know, Ms. Dundas, do you have any guidance for us, particularly on the legal standard to make a determination like this, you know, given the statutory interpretation? Does that feel premature to you or not?
So I think it's kind of a twofold question. I think I'm hearing agreement from all three of you that the commission make a threshold legal interpretation now, and I'll repeat it just for the record, that Senate Bill 21264 gives the commission the discretion to approve a clean heat plan that includes non-enumerated clean heat resources, as long as the commission finds that the clean heat plan maximizes the use of clean heat resources and the non-enumerated clean heat resources achieve a reduction of carbon dioxide and methane emissions from the distribution and use combustion of gas.
And I would just put to the extent practicable in there, because I think there's a reasonableness and practicability portion of that. So would you accept that modification?
It's not really my place to modify the statutory language, but I guess it's where are we putting the extent practicable?
Yeah, to the extent practicable. I'd like to add that.
At the end of that?
Yes, and I think that is based in the statutory language, which has all kinds of reasonable costs and extent practicable language.
So just to clarify, the extent practicable modifies the maximizing use of clean heat resources and not the methane distribution and use combustion.
Correct. Absolutely.
Okay. Well, let's put that to a vote, perhaps. That let's leave aside the application to CNG and offsets now, but are we comfortable making, is the commission comfortable making that threshold interpretation as modified by the chair?
Commissioner Plant.
Yeah, I support that.
Commissioner Gilman.
Yeah, Miss Dundas, sorry, forgot your name. I'm looking for, it's been a long time. I'm looking for the specific language. I mean, I just don't know that it's necessary to add to the extent practicable to legislative language that already indicated several different, I mean, like the entire concept that you could use non-enumerated resources after you've maximized the enumerated resources or the clean heat resources implies that exact thing. So I don't know that it's necessary at all to add that language, and I'm not sure I understand like the exact repercussions, nor why we'd modify what largely is statutory language in
Well,
our legal interpretation.
The reason is this interpretation is across multiple provisions, and maximizing the use of clean heat resources shouldn't be at any cost, right? There's a guidance on limitations on cost. So we're just not going to maximize clean heat resources if they're enormously expensive. So that's why it's really the maximized language has to be qualified in the context of cost issues and to the extent practicable. So it's really the maximized language without some qualification on cost that is my issue.
Ms. Dundas, can you give us like a reading of where the maximized language appears in the statute that we'd be?
Sure. So in section 6 of 40-3.2-108, it's titled the approval of a clean heat plan. If you go down to section C, it lists section D lists the factors that the commission shall take into account. So my recommendation pretty much just copy and pasted A, which is whether the clean heat plan achieves the clean heat resource targets, the clean heat targets through maximizing the use of clean heat resources. So that's a factor the commission has to take into account when approving a clean heat plan. Obviously, there's also a public interest determination down in E, and in D1 uppercase D, it also requires the commission to take into consideration whether the clean heat plan results in a reasonable cost to consumers. So to add to the extent practicable to what I read earlier, I think is adding it to the language I read from it. Does that help?
Yeah. Sorry. Do you think that sort of language alters the statutory language or interpretation? I mean, I wonder if it's better to describe it has to maximize those when considering the other, public interest considerations. I mean, that more directly like links it to what's actually in the statute.
Yeah, including
As
cost.
better language. Yeah. So
I'm fine with that.
instead of to the extent practicable, I would rather link it to when considering, the public interest determinations the company
Yeah.
or the commission must make.
Commissioner Plant?
Yeah, so what we're saying is that to the extent practicable is a little large and vague. And what we want to do is constrain that to cost and public interest. Is that correct? In keeping with the language in the statute. I agree with that.
Does that give you what you need, Ms. Dundas?
I think so. So essentially, I have a 3-0 vote to give the threshold interpretation that I laid out with additional language about how all of the approval of a plan is constrained by cost and public interest considerations. However, that does not affect at all the second clause of the sentence, which is that the use of non-enumerated resources must achieve a reduction of carbon dioxide and methane emissions through the distribution and combustion of gas, which is really the part that's at play in the larger discussion today. So it sounds like we're at sort of the commission's at a place where whether to link that threshold interpretation to the resources of CNG and offsets at this juncture. Sounds almost like a 1-1-1 vote at the moment.
Yeah, I'm not done yet. Let me see if I can make a suggestion to Commissioner Gilman. What if we included language in this order that sort of reflected the concerns you raised and pointed out to the parties based on the record in front of us now? We thought it was, and I'd be happy to use, your language, not reasonably likely that these resources can comply with the statutory standard, but still leave it to the parties to develop the record. So there'd be strong commission guidance about the difficulties and burden of complying with this, but not try and resolve it on a partial record. So I'd be happy with a 3-0 vote. It's probably going to be a TBC order, but a 3-0 vote, talking about the difficulties of achieving this standard, but not trying to resolve it on a partial record at this time, letting the process play out. So Commissioner Plant?
Yeah, I have a question about that. I think that the place where the factual record is a little bit undeveloped is on CNG. The offsets, it seems like, is clearly not there, because the offsets are by definition someplace else, and not associated with the distribution system and the combustion. I don't know if we I want to see if both of you, I know where Commissioner Gilman is, are comfortable saying, we can make a determination on offsets, but the record on CNG is less clear in our in the evidentiary record, and we would need to clarify that. Is that in line with your thinking?
I mean, it's possible you could have offsets that meet the statutory definition. So I wouldn't rule it out at this stage. I just say it's a difficult standard, and maybe they're not offsets outside the utility system or the state of Colorado, but you could see offsets that might help locally. I don't know. It just feels premature to me to rule it out. So that's where my struggle is. It's just trying to, you know, reach an end result on a partial record. So I don't know if that helps. Commissioner Gilman, you want to jump in?
It might not help. I mean, I hate to be the stick in the mud. You know, I think what I'm trying to do is, what are the benefits and risks in any direction of how we move here? And I really do see these issues as becoming just such a big deal. Even if we say it's highly unlikely, you can prove this. I think everybody's going to try, and everyone's going to put a lot of effort to this. And as it sits, I think the company has made extensive arguments for their inclusion, and they are not at all compelling. There is no way in which you can, in testimony, say that certified natural gas reduces emissions outside of the LDC and in upstream emissions, and then later claim it reduces it on the distribution system and the end use. Same with offsets. Like, I don't see where the maneuverability even is in the arguments going forward. So if I could even dream up an offset that could possibly be on the distribution and end use of gas, that's possible. And this wouldn't preclude them from including an offset that legitimately is on the distribution and end use of gas, but that's certainly not what we've seen presented in the Clean Heat Plan thus far. They're outside in different unrelated sectors.
How about an offset
I don't
that
see any likelihood of success, and I think we're going to torture the parties, including the company, acting like there is some clarity that could be provided here when I think we have very significant clarity.
I mean, how about an offset to encourage, 66 customers in Boulder to convert to electric to avoid a major capital expenditure? Could that be an offset?
That's beneficial electrification. That's already a clean heat resource enumerated by the legislature.
Yeah, I don't think that's an offset. I think that, one of my issues, I think offsets, are clearly the reason they're offsets is because they happen somewhere else. That's the definition of an offset. And
that's in the company's testimony already, that they occur
yeah.
somewhere.
And one of the ways in which natural gas can be certified is through offsets. Are they using offsets to certify the natural gas, or is the certified natural gas that they're proposing be certified through offsets? I don't know. That's a little less clear. I do think offsets are offsets because they happen somewhere else, and you offset on the distribution system or offset in the combustion. It's not direct. It's not as the statute is indicating. CNG I'm less clear about because I don't know what the CNG is that they're talking about exactly.
I would just jump in to say that if there's concern that there's offsets that could conceivably meet that statutory interpretation we put forth, the decision could be limited just to the offset that's proposed in the company's application, to not inadvertently capture something that could be invented or proposed in the future.
Does that help you, Commissioner Gilman?
I thought it would help you, Chair, about the conceivable offsets that would be invented by someone more clever in the future.
I mean,
I think the distinction that I'm drawing is, if we are all 3-0 saying it's clear that the emissions reductions need to happen on the distribution and use of gas as identified in the statute, what has been presented as offsets do not meet that definition.
that to me sounds like a deliberation decision, not an interim decision based on a motion for summary judgment. That's my
the fact that the parties want us to decide now. They've all asked us to.
I mean, I think we've given them, a motion for summary judgment could be decided based on the fact that there's no material dispute. So we've disposed of the material dispute issue, and that should end the summary judgment. We've gone further to provide a legal interpretation of the statute because of the joint request of the parties. I think to go further and make a decision about how these facts comply with that statutory interpretation just feels inappropriate to me based on a partial record, not subject to cross-examination. So that's my hang up. And I think we've gone further than we were obligated to go to resolve the motion for summary judgment. So I don't know, Ms. Dundas, you have a thought on this?
I guess hearing the discussion today so far, it sounds, I think you characterized it correctly in the sense that you're uncomfortable applying the legal determination to the record as it stands today. You'd like the record to be developed further. Commissioner Gumman is comfortable applying the legal interpretation to the record today because she doesn't see what further development of it would prove or could prove. I think I did hear at least a potential second vote for developing the record in a limited matter for an earlier hearing. So that may be the middle ground that you're looking for. That's all I have.
So a question for you, Ms. Dundas, is if we're in giving guidance in the way that we have given guidance and indicating our preference, it's not the determination of a legal standard. And the determination of a legal standard would either require, as Commissioner Gilman's suggesting, making a finding here, or as Commissioner Blanken and I have suggested, having a hearing that would make that determination. Is that determination necessary if we're giving clear guidance on what we want to see in a clean heat plan?
I think that the only guidance you've given about what you, and I don't think it's a want, I think it's the guidance you've given is that the statute requires a clean heat plan to reduce the emissions from the reduction of carbon dioxide and methane from the distribution and use combustion of gas. I do think it's whether CNG and offsets as non-enumerated resources meet that standard is a decision the commission will have to make at some point, whether that's today in December or May, unless I guess it's conceivable that they were somehow removed from the plan by the company. But the company has put forth them as part of their preferred portfolio. So assuming no amendment to that preferred portfolio on the company's behest, yes, you'll have to make the decision whether those meet the standard at some point. And the question is just, do you need more information to make that decision? It sounds like Chair Blank says yes, and Commissioner Gilman says no.
And I think in order to make the legal determination, we do need more in the record. I just don't want to wait until spring to do it. I think we need to resolve this before, before January.
Yeah, I mean, that to me is preferable to going into the spring or summer with this still an open issue that I really think is just sucking up attention and time that could be devoted to other substantive issues in this proceeding. So if what it's going to take to get unstuck is me giving you a second vote to get a round of testimony in and do a 1-2 day hearing in December, then I can do that. Not my first choice, but I'd rather us get unstuck. And my absolute last choice is that this waits until the full evidentiary hearing.
I guess for me, it's not that I need or want more evidence to make this decision. It's just premature to apply a factual situation to the law in the middle of an evolving proceeding. Just feels premature to try and make this decision for me. And I guess Commissioner Plant, how do we schedule this, given the three other cases? The phase 2 of the ERP, the phase 2 of the rate case, and the transportation electrification plan. We're already looking at almost 20 days of, with this, we'd be looking at 20 days of hearing in December and January on three wildly diverse issues.
Yeah, I mean, I sympathize with that. I wonder, Ms. Dundas, I don't know what the sort of how the calendar breaks out in terms of required time. Is there the possibility that this could be done either December 1st or the beginning of that first full week in December?
I might have to call on advisors for that. The dates that I had confirmation were open were the 5th and 6th of December. I'm not sure about the 1st.
So that would be the Tuesday and Wednesday of the first full week. And do we think we need 2 days for this?
I think that is a discussion to be had about what we're scoping the hearing to answer and what the burden would be on the parties to provide testimony for that. But it would be a day and a half because it would be a Wednesday morning, it would be a CWM. So I'd imagine withholding a day and a half would probably be around the appropriate amount of time.
Let's see what you think about this. Why don't we deny the motion for summary judgment because there's a material issue of fact? Why don't we get out the legal interpretation of the statute, which we sounds like we all agree on, and why don't we confer with advisors and counsel over the next week and take this up again next week in person. And see if there's a way that, might satisfy all three of us. Commissioner Gilman?
Fortunately, I think we burn a week in that way that we just don't have with the hearings in December. I mean, if the only opening would be to have a hearing that first full week in December, 5th, 6th, I think we need to get going on having a round of testimony filed before then. Probably 2 rounds of testimony, if not 3 before then, and then have the hearing that first week in December. So I don't see burning a week right now. I mean, if this is the direction it's going, where you all think we need additional testimony, I think we have to squeeze it in. That's what we're asking for.
I mean, someone I'm asking for. Commissioner Plant?
Yeah, and I just want to make sure that, if we make a decision today, recognizing the various different time requirements for testimony, that week of the 30th November, 1st of December is not an option.
Say that again, I'm sorry. Commissioner Plant, which dates?
I just want to make sure that in recognizing the various different time requirements of testimony and things like that, that the 30th of November, 1st of December, that week is not an option. The earliest we could do it would be the first full week in December.
I mean, I think it's totally up to your discretion how much time you would want to give the parties to develop testimony on this issue. It is one issue, so it's not like the entire case has to get litigated by December. So yeah, if you think a week for direct and 2 weeks for rebuttal, and then 2 weeks for answer, and then I don't know, 2 days for rebuttal would be enough, then I guess we could move it to the last week in November. But that would be really fast. So it's totally up to your discretion.
You guys have more experience on how long it takes to develop a testimony record, recognizing this is a pretty concentrated issue on offsets and CNG.
I've said my piece. I think it's doable. I think you can go, a week for direct. like I said, they've already submitted extensive testimony on this. 2 weeks for answer, 1 week that would probably include the holiday week for rebuttal, and then have the hearing on the 5th and 6th. And if something happens in the interim, you know, because they've all heard this guidance and interest we've given them, then that works. But that all to me is far more preferable than keeping it in the full proceeding.
Okay,
I'll let you two work this out. I think this hearing is a mistake. I think it's just too much else going on with too much other consequences to try and jam this into December. So I'm probably a no vote. So I'm going to dissent on this, and I'll leave you two to figure out what process you want to do. I mean, it's just, I think it's too much.
The schedule that Commissioner Gilman that you laid out, I think, is probably sounds like it's the best we can do in order to get this resolved before, you know, as early as we can. You know, to meet the burden of the legal standard and the evidentiary record. I think we're safer to have that than to make a summary judgment on that at this point. So yeah, so your time frame that you just outlined, I think makes sense.
So I think what I'm hearing is a 2-1 vote to resolve the question regarding whether CNG and offsets are properly part of the company's preferred portfolio earlier in the proceeding. That would look like bifurcating the evidentiary schedule and hearing and addressing this limited issue earlier in the proceeding. That proceeding or that evidentiary hearing would look at the significance and development of certain issues of fact, including whether CNG and offsets proposed by the company do in fact reduce emissions from gas distribution utilities, whether the company's emission accounting approach comports with the statute, and other facts and legal arguments along those lines. We'd be moving towards a hearing on the 5th and a full day on the 5th and half a day on December 6th. We'd set a direct testimony deadline 1 week from the mail date of the decision, and then working from that date 2 weeks for answer testimony, 1 week for rebuttal, and then hearing on the 5th and 6th on that limited issue.
And can I make an amendment? And I just like to ask the parties whether this alternative with a whole bunch of separate filings and a separate hearing is really preferable to just keep into the existing schedule.
Well, there is no existing schedule at the moment.
Keeping to the existing plan or whatever would likely arise if we didn't schedule this process.
So, Chair, would you like to set a deadline for responses to your decision? Is that what you're suggesting?
Yeah, maybe.
Okay, vote on that, I guess.
I'll just invite responses from the parties. I don't know. Commissioner Plant.
Yeah, I'm not sure. I'm not sure I followed.
I guess I'm just asking you. I just would like some guidance from the parties whether this alternative process is superior to. I mean, the concern is that we're going to somehow strain the parties by keeping this on the current path, and I just question whether having a whole separate round of filings and hearings is better. And would welcome guidance from the parties if there's a way to get it. Commissioner Gilman.
Ms. Dundas, I'm good with what you laid out. The only modification you had mentioned whether they reduce emissions from the companies, it's whether they reduce emissions from the distribution and use of gas, which I think is actually an important distinction, because often offsets are seen as a way of reducing, say, corporate emissions that do not actually hit the discrete section of a physical system we're talking about. So I would just make that distinction in language, that the language should stay consistent, distribution and use combustion of gas. But other than that, I am okay with your schedule, and we'll do it.
And I'm
Commissioner
assuming
Platt.
that, thank you, Mr. Chairman. I'm assuming that if the company responds with an intent to change their submission, that this would then be able to be vacated at some point. Is that correct?
I imagine that if the company was going to amend their application, that would be done through a motion, and the motion would be brought to a future CWM, which would address that, and that would be a decision for then whether to vacate the hearing or not.
Okay, great.
So, okay, sorry to repeat myself. So we're working towards a 12-5 hearing. We're going to go with the dates that, or there's a 2-1 vote to go with the dates I laid out. Does the commission think there's a need for a pre-hearing conference?
Commissioner Gilman.
Specific to this issue, Ms. Dundas, or for like the rest of the?
I think specific to this bifurcated first hearing.
I don't think so, unless you see like a reason that would be helpful.
Not necessarily. I'm not sure if advisors see a reason to do that or a possible date.
Ms. Dundas, do we want to add in any, like, if this is going to run like a normal hearing with cross-examination? Just thinking, okay, so the answer testimony is due the 17th. Sometime in that last week of November, we get a matrix so then we can better plan the time here and understand if maybe the second day can be vacated or whatever. So probably that last week in November, we get a cross matrix like we typically get, just so we can better understand how the hearing's going to flow. I would just add that.
Okay, like a December 1st deadline for
Yeah,
cross matrix.
that seems reasonable. Yeah.
Commissioner Plant.
That sounds good to me.
Ms. Dundas, I guess this is going to be a TBC decision.
Yeah, so I think we have a TBC decision for a 3-0 vote that denies the motion for leave to reply, a 3-0 vote that denies the motion for summary judgment, a 3-0 vote to set forth certain legal analysis as guidance to the party, and then a 2-1 vote addressing the procedural steps, the next procedural steps that were outlined. And would you like to write a dissent, Chair Blake?
Yeah, I think so.
Okay. And would anyone have said that differently to summarize what came out of today?
Commissioner Plant.
Nope, that sounds accurate.
Commissioner Gilman.
I think you got it. Thanks for bearing with us, Ms. Dundas.
All right. Thanks, Ms. Dundas, and really nice job presenting the issues. Greatly appreciate it.
I'm sorry, I might have
Oh, you got one more
thing.
issue. Yeah.
I perhaps heard from advisors that it is it would be a good idea to hold a pre-hearing conference to establish discovery procedures to fit into the expedited schedule. It could also be an opportunity for sort of informal feedback on the process outlined. Do advisors to call on a friend have a proposed date for something like that? I think perhaps the afternoon of the 26th could work.
Good morning, Commissioners. I'm Ron Davis of the Commission's advisory staff. And yes, I do think that the afternoon of the 26th of October would be a viable time to have a pre-hearing conference in this matter. And perhaps, is that the date you were thinking, Ms. Dundas?
Yes, and I think if we go, I don't think any earlier the decision will be out. So I think the 26th would be fine.
I really like that. Then we can get some guidance from the parties about how they'd like to proceed. So I think that's a very good idea, and I'm free on the 26th. Commissioner Plant? Commissioner Gilman?
Works for me.
All right, Ms. Dundas, anything else?
I think that's it, Mr. Davis.
Mr. Davis?
I think that's it. So I just want to make sure Ms. Dundas knows what she needs to do in terms of crafting a TBC decision and scheduling a pre-hearing conference as early as the 26th. Perhaps we need multiple decisions here.
I'm a very fast writer, but that could help. It is. I guess that decision should be made now. Can we do a preliminary decision, scheduling the hearing, scheduling the pre-hearing conference, and laying out the testimony deadlines, and then a second decision to follow short after that would be TBC, which lays out the legal analysis and the findings on the motions.
That works for me. I think that's a good idea. And thanks for leading us there, Mr. Davis. Commissioner Plant?
That sounds good.
Commissioner Gilman?
Yes, that works. So the first one will be pretty cut and dry. It's dates and process. And the
Yeah,
other
that's a 2-1 decision on the ABC,
Fine.
and then
okay.
the TBC decision will carry the substance on the discussion for the first 90 minutes or so today.
Thank you.
Anything else, Ms. Dundas? Mr. Gomez, Northern Cheyenne tribe issues. It sounds like that we're gonna delay that for a week.
Yes, the members of the tribe had asked that we delay this 1 week until the 25th.
So we'll table this till next week. Anything else on this one, Mr. Gomez?
That's it.
I think that concludes our agenda. Commissioner Plan, any final thoughts before we adjourn?
No, thank you.
Commissioner Gilman?
Nothing additional.
All right, we're adjourned. Thanks all.